we did not come with an agenda today. We really want to, just move forward as we have said, with seeing if we can reach an accommodation agreement. I'll just begin with a few opening comments, just to kind of set the tone of where we are, where we'd like to go. And then if it's all right with you all, dive right into the MOU like we did last time, and let's just go on through.
Louis, the only thing I would say is I guess I'm a little surprised you all had sent Jeanette, which I thought was very helpful, those 9 items. So our understanding.
Yeah, and those were not meant to be the basis of a negotiation, point by point, but rather the whole body of the MOU, because we have to reach that to get to where we want to go. I'm glad that was helpful, but it was really just framing where we are. And let me just make a couple of comments, just to get us going, and then we can dive into the MOU. And this is going to be very informal. As you all know, we're not a governmental entity. The Gibson Island Corporation, with a full-time dedicated staff with expertise in all of these areas. We're all neighbors. We're all fellow shareholders, and we've invested significant amounts of time and energy towards this matter. As we mentioned in the yesterday's email, we've had 7 board meetings on this issue alone just since December. But given the long and contentious history of our dealings, the corporation board is determined they will only move forward on the strict condition that whatever we agree to will be memorialized in a legal document with conditions that are clear. That's what our board has decided. And the board is we've set out, has decided this unanimously. So if we're going to move forward, we're going to need to do so with this MOU as the basis for our negotiations. And as you know, as I've tried to say, is that it contains several key points and points that will, are aimed at protecting the interests of all Gibson Island shareholders, including you and the potential residents of your facility, but all shareholders. I've dealt with MOUs throughout my career. They're a working document. They're intended to, lead to a definitive agreement. It's the contract equivalent of a letter of intent, which is often used in mergers and acquisitions, where I saw them quite a bit, in company sales, property sales, financings. It's a standard legal tool in situations such as this, and one that we agreed to use going forward. Our board directed us to see if we can grant a reasonable accommodation. We're trying. However, as you all are well aware, we've spent a lot of money protecting the interests of all our shareholders, and we can't bear those costs forever. Our volunteer board members have spent hundreds of man and hundreds of women hours on this matter, and it's not sustainable over the long term, over the medium term, or even over the short term. We simply can't afford the burdens to continue that this is placed in our collective time, or frankly on the money of all of our shareholders. As we are all aware, the corporation operates in a really thin budget that, and this is financed by fees and charges paid by all of us. We have less than $3 million in annual revenues. And in a good year, our budget is designed to, at best, break even. At least that's the hope. Over the past year alone, we've spent in excess of 7 figures, over $1 million in legal fees alone related to this one issue. That's money from all of our shareholders. And frankly, to spend over 25% of our annual revenues on an issue that's related to a single shareholder, in addition to the inordinate amount of time that we've spent, frankly, has been in the, up to this point, an undue burden. It's been a burden financially and administratively, and it's not sustainable. And if we move forward, we're going to need assurances that these burdens will fall away, will go away. We're going to need an agreement that's enforceable. It's going to be an agreement that protects us as a corporation, and it protects all of our shareholders, including you all. And it's going to be we're looking for an agreement where we can trust that the mechanisms for those protections are there and that they're enforceable. And before we dive into the MOU, I just want to make two other quick points to frame this. One, despite what anybody says, there are no other businesses operating on Gibson Island. There is no business district, full stop. The second point is, our recent emails have said this, is that, and the three of us have reviewed this extensively with our lawyers. The Carson agreement does not come into play here. It is not relevant to this MOU, and it's not relevant to any potential accommodation agreement. And that's I just wanted to make those points up front. So, with that, I'm ready. We're ready to, or actually, Bill or Patty, if there's anything that you'd like to add. I hate to drone on.
No, you've summarized it well.
Very well, Louis. Thank you.
So I'll get in. Also, as I mentioned, Craig and Jeanette, in our email, we do have a hard stop at 5:30. A little 2 hours and 6 minutes from now. Going into the MOU.
Well,
really,
Louis,
the first.
I appreciate that you took the opportunity to make some opening statements. I'd like to respond to those. Again, we were under the misunderstanding that these 9 items, we assumed that the dumpster was a settled issue, that telling people about the club was probably a settled issue, provided that whatever was presented to be told to people was accurate. You talked about the legal fees being an undue burden. What you sent us, we took in the spirit of moving forward. We took time to comment on what you sent us, and we thought that was going to be what was discussed today.
That will be discussed today because all of those issues are in the MOU.
Louis, could I we didn't interrupt. I just would like to make a few statements based on what you said.
Mhm.
That's right. So as we said, and again, we took the time yesterday evening and this morning, as we said in what we sent back to you all, whether it's called an MOU or an AA or an ABC, whatever the document is, a letter of intent, all of these discussions, all the discussions that we have had with other members of the board since the spring of 2016 under the joint statement, they're all binding, they all matter. So the objection to the MOU format is that it's somehow not binding. It is binding, and we just want to make a statement. It's binding. The things we say here, the things we've said before, all the emails, it's all binding. Because when I can sit and have a conversation with Greg Cross and ask him a question, I don't have to say this is for an accommodation. I ask him a question, he responds. I give him an alternative, he responds. Under the joint statement, all those things are binding. So again, don't mind that it's called MOU. It's the non-binding nature of it. With regard to your legal fees, again, we said this as softly as we could in what we sent back. The legal fees on this issue for both of us started on March 25th. They can't possibly have started before, because you all have said time and time again in the resolution, in the litigation that you filed against us, that you didn't know about it until the 25th of March. So any legal fees, and there were huge legal fees spent by the corporation prior to this, had nothing to do with Banbury. The other thing that you say there's no other business agreements. As far as no other business agreements, the question was not about business agreements. Questions we asked is the water department, the water building, the water plant was sold in 1951. That is a business on the island. We never said there was an agreement. In fact, we asked for the agreement to approve the church between 1928 and 1933, and we've never received it. So there are other pieces of property that are owned by others. And other than Henry Hopkins telling me in an email that if the church ever fails and goes bankrupt, that property goes back to the corporation, there are 2 other businesses that are not owned by the corporation that have been functioning. And again, so that's another, another piece, another standard. So we don't have the MOU in front of us. What we have are what we sent and the 9 things that you all sent, because that's why we thought you sent it. That's what we thought we were going to discuss. So we're happy to discuss whatever you want to go through now.